Welcome to episode 22 of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without benefit of footnotes, and nothing we say should have been taken to be thoroughly peer-reviewed. I'm Associate Professor Imogen Saunders, Director of the Australian National University Centre for International and Public Law, and this evening, or this morning in the UK, I'm speaking with our regular co-host, Professor Douglas Guilfoyle of the University of New South Wales, Canberra, and Dr. Alex Green, Senior Lecturer in Law at the University of York. In this episode, we continue a theme, perhaps, from the last episode on the fate of the Chagos Archipelago, in that we are still focusing on international law and islands. Today, we'll be discussing Alex and Douglas's forthcoming article in the American Journal of International Law on the Australia-Tuvalu Falepili Union Treaty, being notable both as the world's first treaty to provide a human mobility pathway for climate resettlement, but also for containing a controversial security clause that gives Australia veto powers over a wide domain of Tuvaluan foreign policy. The breadth of that clause and the treaty's potential intrusion into other areas of Tuvalu's autonomy have led some to question whether the treaty erodes Tuvalu's sovereignty or constitutes a neo-colonial arrangement. But before we get to that, what's your drink, everyone?
Well, thanks for hosting, Imogen. It being the first sort of spring evening that's really beginning to feel like summer in Canberra. I'm hydrating with a San Pellegrino limonata, but after that I'm going to be turning to a rather buttery South Australian Chardonnay.
Very nice.
I'm mainly drinking Jealousy at the moment because it's first thing in the morning in Yorkshire, and it is both grey and wet. Mine is green tea, I'm afraid, a lot less exciting than a buttery Chardonnay.
And that sort of breaks a fine Yorkshire tradition of Yorkshire tea, I should think. But green tea is probably far better for your oxidants. Imogen?
Well, Doug, I'm joining you on both your drinks, actually. And I'm joining you with the lemon theme, but I am, for once, imbibing something more alcoholic than I have been on the podcast. And I'm having a very nice limoncello spritz to enjoy the beginning of what feels like maybe the start of real spring. Alex, in Canberra, we have fake spring that deludes us all into thinking that the cold weather is over and then we get a final cold snap. And I think maybe
we have that in Yorkshire as well. It's fake spring followed by fake summer followed by autumn again.
So Alex, as our first-time guest on the podcast, it's something of tradition that we ask new guests to say a little bit about their background. And what we're really interested in is how people get to the point in their career that they are now, because one of the things we've found is that there is no set path in academia for anyone. So could you tell us about the career path that has brought you to your present job?
Yes, thank you. First of all, I should have said this before. Thanks so much for inviting me onto the podcast. I'm an avid listener and, as you say, first-time participant, so I'm really excited and grateful to be here. I mean, in terms of my career path, there's nothing too atypical, I think, for an academic. I'm a sort of one-trick pony in terms of my past institutions. I did my undergraduate, master's, and PhD all at UCL in London. I oscillated for a while between going into private practice at the bar and academia, and the point at which I definitively decided on the latter was when I was doing an internship at the International Criminal Court and preparing some very, very detailed notes for the cross-examination of witnesses in the Kenyatta prosecution. And I thought to myself, oh, goodness, no. So this was possibly a revelation aided or abetted by the fact, and I suppose I can admit this now, several years on, that I had a copy of a book by David Hume open on the screen beside me while I was doing this work, and I kept chancing across, and I was like, if you're that interested in the theoretical side of things, maybe witness examination prep is not for you. So when I left the ICC, which in other respects, I enjoyed immensely, and it was a really interesting time, I applied for a PhD at UCL, as I say. I suppose the only odd thing about that trajectory, as well as having what I think is a record number of supervisors, Douglas included, for a little while.
I think there was some momentary window when I was holding the fort between people who really knew what they were doing. My fluency in David Hume being, far more fluent in the International Criminal Court than David Hume on this side. But anyway.
Right. But yeah, so I had quite a fair few supervisors. I think largely due to how odd my thesis was. And I was very lucky. I got a job about halfway through my PhD in the University of Hong Kong, and I moved out there um, for a few years, which was wonderful. But it did slow things down a little bit. So that was possibly the only kind of bump in the road. I was the reason I'm now in the UK actually is that I was on a government buyout and doing a visiting position in Cambridge and Leeds, and then COVID hit, and I couldn't physically get back. So I had to quit that job, and after a brief stint at Leeds Beckett University, which was really lovely, I moved to the University of York, and here I am.
Well, I very much enjoy York as a city. I have to say, we've been a couple of times, uh, taken the kids to the Viking Museum, done all that kind of
I love
thing.
that place.
Yeah.
One of
Um,
my earliest memories as a child was of that museum. I must have been about 6 or 7, and it was pouring with rain. Shocker. This is a theme apparently in Yorkshire. And I stood outside, and they have these people you'll remember dressed in all the sort of Viking garb with the chainmail and the axes, and this huge peal of thunder crashed across the sky, and this fella lifted up an axe and screamed "Thor" really loud. And at that point, I was just like, "The Vikings are so cool." So I was hooked as a little kid, and I went back there very recently myself, and it was as cool as I remember.
yeah, I was happy because we didn't have the special effects of the thunder, but I went when I was 12 and then went back in 2015 and it stood up really nicely, I thought.
It's fantastic. So, listeners, when you're in York, the Viking Museum,
Exactly.
definitely not sponsored, but definitely worth a visit.
Called to the bar recommended. Uh, so turning to the subject of our podcast today, Douglas, what does the Falepili Union Treaty formally cover? What are its terms?
Right. Well, this treaty appears to have been negotiated in the course of 2023 and has very recently come into force. Alex will correct me if I'm wrong, I believe in August of this year. And
That's
it's
right.
quite
Yeah.
right, and it's quite short. Okay, so I'll go into probably a little more detail than I usually would. The treaty text itself consists of a preamble and just 8 articles. So the preamble reaffirms the parties' sovereignty, territorial integrity, and political independence, and refers to their shared interest in each other's prosperity, stability, and security, including by responding to climate change. Article 1 sets out the treaty's purposes as being to provide mobility with dignity for the citizens of Tuvalu to Australia and to protect and promote collective security. Article 2 expresses a commitment to work together in the face of the existential threat posed by climate change, including through adaptation measures. It also provides for Australia's ongoing recognition of the statehood of Tuvalu, I think a point Alex will come back to. Article 3 requires Australia to establish a special human mobility pathway for citizens of Tuvalu, enabling them to live, study and work in Australia and access Australian public education and healthcare. To support this, Tuvalu is required to ensure that its immigration, passport, citizenship and border controls meet international security standards and to make those systems accessible to Australia. Article 4 provides the reciprocal security guarantees. So Australia undertakes, following a request from Tuvalu to assist in response to a major natural disaster, a public health emergency of international concern, or military aggression. And the really controversial clause under Article 4.4, Tuvalu shall mutually agree with Australia any agreement on security and defence-related matters with other partners. We'll come back to that in a bit of detail. But Article 5 then establishes a joint committee consultation mechanism on implementing the treaty. Article 6 deals with the settlement of disputes through consultation or negotiation. It provides that disputes related to the interpretation, application, or implementation of this agreement shall be resolved by that joint committee, though on written notice a party may suspend compliance with the treaty pending resolution of a dispute. The composition of the committee is interestingly not anywhere specified in the treaty, and notably any dispute arising under the treaty, and I quote, shall not be referred to any national or international tribunal or court or any other third party for resolution. Now, Australia had previously inserted such a clause into its treaty dealings with Timor-Leste, though that ultimately failed to prevent a compulsory conciliation process under the UN Convention on the Law of the Sea. Article 7 provides that the treaty may be amended in writing by mutual consent, and Article 8 provides that the treaty will come into force through an exchange of diplomatic notes, which appears to have occurred in August, and provides that the parties may terminate the treaty by mutual consent at any time, or it can be terminated unilaterally on 12 months' notice. And that's the treaty in a nutshell.
Wonderful. And perhaps we'll put a link to the treaty text in the notes to this podcast as well. But Alex, Doug said that, we're going to return to these questions of statehood. So I might turn to you then and ask, what do you see significant about Article 2.2 of the Union in particular?
Yeah, so I have to admit, when I first read the treaty text, Article 2 jumped out, not just because this is something I've been writing on for a little while, but just because it really is very unusual, groundbreaking, really. So I'll just briefly read it out. I think that probably makes sense. So Article 2 itself is called Climate Cooperation. And Part 2 of that reads, the parties recognise A, the desire of Tuvalu's people to continue to live in their territory where possible, and Tuvalu's deep ancestral connection to land and sea. B, the statehood and sovereignty of Tuvalu will continue, and the rights and duties inherent thereto will be maintained, notwithstanding the impact of climate change-related sea level rise. And C, that more recent technological developments provide additional adaptation opportunities. Now, 2C is obviously declaratory of a matter of fact. A and B, however, are extremely legally interesting. So A is a clear recognition of the long-standing policy of Tuvalu and a lot of other large ocean states in relation to their desire to continue living on their ancestral lands, notwithstanding sea level rise. And B, as it were, the operative part, is particularly interesting because it is the first time ever, certainly in a binding treaty, that states have recognized formally that sea level rise will not affect the continuing statehood of political communities subject to it. So by way of sort of explaining just how important this is, the law of state continuity as it exists in customary international law is unclear, or it has been for a little while. Some would say a mess. It's thin on the ground because practice is thin on the ground. 9 times out of 10, it's pretty obvious when a state is there because, you sort of look at it and, ecce polis, there it is, functioning as a state. The circumstances in which state continuity comes into doubt are almost always, or have been almost always up until recently, political and social. And it's typically the invasion of a foreign power or widespread civil unrest or some combination of those things that typically results in something like a government in exile. Sea level rise presents a completely unprecedented challenge because it is it contemplates a loss of the physical area in relation to which the territory of the state exists. Now, as many of your listeners will know, the International Law Commission is looking into this in some considerable detail, and I've been lucky enough to be an observer there and have some interaction with members of the Commission on this issue. But in terms of state practice as it exists, we've had a number of declarations dealing with this issue in much the same terms from the Pacific Islands Forum and more recently from the Association of Small Island States. But never before have we had, particularly a state with a large economy that is regionally important, like Australia, effectively tying its hands in perpetuity and saying, no, we commit to recognize the ongoing statehood and sovereignty of Tuvalu, notwithstanding. So this does a couple of things, I think, and that Douglas and I discussed this in the paper, of course. One thing it does is it cements bilaterally the status of Tuvalu vis-a-vis Australia as what Rowan Nicholson has really usefully, I think, described as a state in context, right? So no matter what this means, right, is no matter what the general position is in relation to Tuvalu's statehood, as far as Australia is concerned, Tuvalu is a state on an ongoing basis, and that provides a formalized level of protection that is I suppose, quite comforting in legal existential terms. The second thing that it does, and only time will tell the extent to which this impact is felt, it provides a model for other bilateral and possibly multilateral treaty relationships. I think a pretty good model that other states, other powerful states, might consider following. Now, I'm not aware of any movement in that direction from any other large economies or great powers, but assuming that there is some uptake at least, or that the language is further promulgated in documents of other kinds, what we might start seeing is a further crystallization of state practice and opinio juris that will bolster or solidify that somewhat vague or messy area of state continuity that I mentioned at the outset. So, I mean, this is really, the word revolutionary gets thrown around a lot, and possibly a bit hyperbolic, but as far as law goes and the incremental developments that international law tends to see, this is as close as it gets, in my view. It's really a quite a dramatic precedent. And possibly the beginnings of a shift of approach. I certainly hope so.
Yeah, that's really fascinating, Alex. And I'm just going to step back for 1 minute for listeners who might not be as familiar with the intricacies of statehood as you and Douglas are, because as you said, the issue here is that Tuvalu and other small island states are likely to lose their I actually really like the phrase you used, the physical land to which their territory rests. And of course, when we look at statehood, territory is one of the 4 criteria of statehood. And so that's why it's such a significant thing. When we talk about loss of territory, states have to have a permanent population, a defined territory, effective government, and the capacity to enter into legal relations. And so once a state loses its territory or loses the physical space where its territory was, that's why these issues of continuity of states come into being.
Yes, absolutely. And sorry, I should have mentioned this. It's the subject specialist's curse, I'm afraid. I spend so much time talking and writing about the Montevideo Convention and the criteria that you've just mentioned, which are set out in Article 1, that I sort of forget that the rest of the world doesn't dream about it as well.
I think
there's a couple of... Yeah, sorry.
I was just going to say, I think when I did my podcast with Doug on general principles, he had to remind me to explain what they were because I just assumed everyone knew.
It's the role of the non-specialist chair in this podcast, right? You have to be the person prepared to sort of say at various points. Now, just stepping back a bit, but it's all part of the format.
It's like that meme, isn't it? Pause, Montevideo. but yeah. So there's a couple of things about the Montevideo Convention in this context that is actually quite interesting. So often you will see, and I suppose I've replicated this error. So apologies for that, everybody. That territory is the thing that is focused on specifically, but actually it's a little bit more complex than that because. Montevideo, of course, talks not only about territory, but also about permanent population. And up until relatively recently, it's been assumed that that means resident population. In my book on state creation, I say that as well. The interesting thing about the law of state continuity is that in this circumstance, we might want to think about it not as a resident population. And the reason is that long before the territory in question, or the land in relation to which the territory exists, becomes submerged, it is likely that the real problem will be the exodus of the population due to the uninhabitability of that land. Well, as sea levels rise, you get increased salinization, and you also have increased impact from climate-related disasters, storms, and so on. And so it's the loss of population that is possibly the more immediate danger, which is another reason, of course, that the treaty in general is so significant, because it is fundamentally a climate resettlement treaty. So it's very important, I think, from that point of view, that this provision on state continuity is in there. The other thing I wanted to mention about Montevideo, and I think this is a mistake that is quite often made, and did come up in discussion in the International Law Commission while I was there. The Montevideo Convention does not mention state continuity at all. It's not a convention about state continuity. In fact, it's not even a convention about state creation, although that's the context in which it's most often cited. It's a convention about the rights and duties of states. And the function of Article 1 in the text is simply to identify what counts as a state for the purposes of the rights and duties that follow later in the convention. Now, states subsequently have taken Article 1 and sort of run with it. So what we're looking at really is not an authoritative text so much as a body of practice that's sort of riffed on it. But the important point that follows from that is that the wording of Montevideo and the context of its drafting and passage into force is actually quite a small part of the relevant customary law, and people shouldn't get hung up on it. What's much more important is how those criteria are interpreted now, as it were, after the fact. And that's where I think the vagueness comes from. Because in the context of Montevideo, all of that meant a certain thing, but we're not in that context anymore. Sorry, I've got on my hobby horse. I'll get back off it.
No, but I think, Alex, you make a point of general importance, right? Which is that we all tell our students, whatever you do, read the treaty, right? Because so many people just go off on points of international law based on not actually having looked at the primary sources at all. But then every treaty exists within the context of a sort of specialized professional or epistemic community where the terms will in practice take on kind of shades of meaning that possibly detach from, or in some cases completely reverse, the literal meaning of the text. So you have to be alert to both of those things. But one can have precisely that same conversation with a law of the sea lawyer about the interpretation of certain provisions of the UN Convention on the Law of the Sea, or with a space lawyer about what once appeared to be prohibited under the Outer Space Treaty is now seen as kind of generally acceptable, and we're not debating the principle, only the method of execution. And for every specialized treaty regime, you always have that dynamic. So I think it is something worth drawing attention to. But it does lead to the problem for us as teachers of international law, right? Where we tell our students, go read the treaty, and then pretty rapidly have to follow up with, oh, no, not like that.
Yes, absolutely. I mean, context is king, right? That's true in all areas of academic study. I think it's particularly true in law. The context of Montevideo makes this common error all the more ironic, because historically, the reason that Montevideo was created was the Latin American states didn't want their statehood to be denied on the basis that they weren't recognized. So the function of Article 1 is to sideline recognition for a particular set of historically contingent purposes. Later on in the treaty, there's, I think you've just said read the treaty, and now I can't remember. I think it's Article 3. That's probably wrong. You'll have to sidebar this next time. I think it's Article 3, effectively says recognition is irrelevant to the status of states. It's a purely political act and declaratory of that status, not constitutive of it. So that was the context of the debate that was happening back in 1933 when Montevideo was signed and ratified. Now, today we're facing a different challenge in relation to the law of statehood. And it's interesting because the problem, to a certain extent, is connected. It's about here the ongoing recognition of states whose status is at least prospectively called into question. But the irony is yesterday's tool for securing that status, for securing statehood, which, as we all know, is so important in the international legal order, is now today's roadblock.
Mm.
And this is the problem with things that humans make, right? They're not good for all purposes.
And I don't think that interpretive challenge or that challenge of legal technique is unique to the law of statehood, right?
Absolutely.
It crops up in all sorts of other areas where if you don't understand the problem that the lawyers were trying to fix with this drafting, you won't understand some of the ways out of the problems that drafting in turn will go on to cause. And if you treat the law as this sort of immutable holy text that was handed down, rather than as a response to a particular set of social concerns and evils that law was trying to grapple with at a particular time, then yeah, you can get yourself into real difficulty.
Mm.
I absolutely agree, which is why everyone should be a non-positivist.
Rubbish. Imogen.
Well, I'm going to throw back to you, Doug, because I mean, Alex has gone through really wonderfully the significance of the statehood part of the treaty, but the treaty was also controversial. Can you explain why this was so and what was done to allay some of these concerns?
Right. So one of the difficulties is that Tuvalu is quite small, right? It's a group of 8 islands with a population of around 10,000. But despite that scale, a real problem was a perception that there was a lack of sufficient or indeed any public consultation, either with the resident Tuvaluan community on the islands or the diaspora in Australia and New Zealand and elsewhere during the treaty's development. So after the election at the beginning of this year, which we'll come back to, the incoming government actually sort of gave the new Prime Minister gave interviews on television saying, we were really surprised by the text and we were members of Parliament. And it's a very small legislature, right? It's about 16 people. And he said not even everyone in cabinet was necessarily consulted. So beyond that issue of transparency, other concerns have included whether the special mobility pathway was to provide for residents in Australia only or a pathway to citizenship, and any implications that might have for Tuvaluan citizenship, going to Alex's points before, the extent to which Tuvaluans could access Australian healthcare, education and other public services, the extent to which Article 4.3 in the security provisions required Tuvalu to grant Australia unconditional access to its territory without prior approval, the risk that adding 280 visa places for Tuvaluans to Australia, in addition to the existing 150 places available in New Zealand, could lead to a completely unsustainable loss of population, like about 3.8% of the population migrating annually if all those places were filled. And also symbolically that it risked signalling that the Tuvaluan government had given up on climate change. But the two biggies that were said to compromise Tuvalu's sovereignty was that provision we spoke about before about providing extensive access to immigration, passport, citizenship, and border control data. And then the biggest of the big was Article 2.4. I'll quote the full language, that Tuvalu shall mutually agree with Australia any partnership, arrangement, or engagement with any other state or entity, we can come back to why entities there, on security and defence-related matters. Such matters include, but are not limited to, defence, policing, border protection, cybersecurity and critical infrastructure, including ports, telecommunications, and energy infrastructure. Now, obviously, that's a very broad-ranging definition of security. And when you unbundle it a bit, in particular, in relation to kind of state or entity, the barely subtextual reference here, right, is China's bid for influence in the greater Pacific region. The entity in question effectively being Taiwan, right? And Tuvalu is one of the last, I think, dozen states that recognizes Taiwan over the People's Republic of China. And we've also seen other occasions where, for example, on cybersecurity and critical infrastructure, Australia built the Coral Sea cable system to link a number of states and basically did so to avoid China installing that cyber network. Nonetheless, for the reasons you just outlined, all of this became very controversial in the 2024 Tuvalu elections at the beginning of the year, and may well have cost the Prime Minister who concluded the treaty his seat in the legislature. And so in the Australian Senate, when Senator Shoebridge was quizzing the Australian Department of Foreign Affairs and Trade on the treaty and the result of that election, he characterised the election as a referendum on the treaty, one in which the verdict of Tuvaluans was, and I quote his somewhat colourful language, bugger that, we don't want to be colonialised by Australia. Obviously, the most intriguing part of that statement being the creation of colonialised as a verb. But okay, so what was done to overcome that that perception that this was potentially a very intrusive and possibly unfair treaty? So the first thing to say is that Australia opened the checkbook, right? So Australia committed to a substantial increase in development assistance to around $87 million in 2024-2025 compared to 17 million in 2023-2024. So that's a massive ramp up in the Australian investment in Tuvalu. And that was itemised as going towards direct budget support to the Tuvaluan government, further support for coastal adaptation measures, seawalls and such, Tuvalu's first undersea telecommunications cable, so again, Australia building critical infrastructure before anyone else can, and a new disaster response coordination centre. Now, other than just kind of attempting to, I don't know, buy consent with gold, a legally significant measure was that the two states released a joint explanatory memorandum regarding the treaty, which made a number of points, which I won't belabor, but I'll just go through quickly. So it clarified the range of benefits that, and I quote, genuine Tuvaluan citizens would enjoy under the pathway, which would include access to education, educational loans, government-funded healthcare, family and disability welfare schemes, and the right to apply for Australian citizenship without renouncing Tuvaluan nationality. And it was also very clear that that Tuvalu does not need permission from Australia before it starts to talk with other partners. So it's not an integrated partnership model. Australia does not have unqualified rights of access to Tuvalu's territory or airspace, nor the right to establish military areas in Tuvalu. All of those things would have to be separately agreed. So, and I quote, the position in the explanatory memorandum was, Article 4.4 does not diminish Tuvalu's standing in global fora. It will not preclude other partners supporting Tuvalu's economic and development interests such as education, health, waste, climate adaptation, gender disability, trade, or granting fishing licenses. And it was expressly stated that cooperation with members of the Pacific Island Forum would not be of concern. Now, the significance of that joint explanatory memorandum is not that it's binding per se, but the parties did say that the treaty would be interpreted in accordance with the memorandum. So that makes it an instrument made in connection with the conclusion of the treaty in the sense of Article 31(2)(b) of the Vienna Convention on the Law of Treaties. So it's something that you would have to take into account in any future interpretation of the treaty. And that's probably more than enough for me kind of rattling through the controversy and the cure. So I'll leave it there.
I do like the VCLT reference at the end, Douglas. It felt like it was a good exam question, perhaps, for our law students. And I think just one thing I just want to pick up on that briefly is, we've said this in previous podcasts too, but people outside the region might not always be aware of Australia's colonial history in the Pacific, that Australia did have colonies. And so, of course, there is real sensitivities around the idea that Australia might be sort of re-emerging or recreating those relationships.
Absolutely. And given the very short memory of the Australian elite and governing classes. I think it's really, it's just not even part of popular consciousness that under, the League of Nations and UN mandate system that, we ran, Papua New Guinea and Nauru, admittedly Nauru with the other members of the Phosphate Commission, the UK and New Zealand, but that we had genuine aspirations to a mini empire within the British Empire, and that there were government policy papers that talked about the Pacific Islands as being, a sheltering screen for Australia's security. And I still think, even if there's a formal and hopefully substantive matter, the attitudes have changed. I don't think the strategic outlook has, which is part of the reason it was such an issue in Australian domestic politics when it turned out that China had concluded a policing arrangement with the Solomon Islands. We're like, well, why are they going to be, policing paramilitary or military forces in one of these islands that we still see as, once upon a time, I think we said this even last week, that once upon a time we would have said, our backyard rather patronizingly, and now we say more inclusively our neighborhood. But we still see it to some extent as, I think at a realpolitik level as a sort of an Australian sphere of influence where we don't want to see potentially hostile powers having bases.
Yeah, and the other thing too that made me think was when you're saying, that it was Australia's ambition to have a sort of mini empire in our backyard. I think it's why in the press releases about this treaty, our Prime Minister kept saying it's a Pacific-led solution. But of course, that contrasts with, as you just went through, Doug, the lack of consultation perhaps with Pacific leaders.
Well, it's hard to unpick the origins of the treaty, but the very, very consistent position put by Tuvaluan politicians is they formed an eminent persons group. They looked at the risks. They went to Australia looking for a treaty relationship. Now, of course, all of that may be completely true, but obviously the Australian quid pro quo is Article 4.4 on security.
So, Alex, Doug has explained some of the concerns about Tuvalu's sovereignty raised by the treaty. In your excellent article, you situate the treaty as it were on a spectrum between treaties of protection and treaties of association. Could you explain the difference between these two types of treaties and where the Falepili Union Treaty lies?
Yeah. So, I mean, this is historically quite interesting, of course, but also important in contemporary terms. Some scholars treat treaties of association and treaties of protection as categorically different things. I don't really take that view. I think in much the same way as we now call our backyard our neighborhood, yesterday's protectorate is today's associated state, up to a point and with important nuances, of course. But fundamentally, I think this is a change in labeling. However, there are some substantive differences in the particular treaties. And this is the first point I would make, is that it doesn't matter so much what you call treaties of this kind, whether it's treaties of association or treaties of protection. What matters is the substance of the text. This appears to be a theme of this episode, but there you are. What one looks for is, as you say, a sliding scale. And it's the extent to which the text in question enables what we call in the paper, and I've called elsewhere in other contexts, intergovernmental domination. So we're looking for the extent of legal authority exercised from abroad to the exclusion of local rule. Now, where that is total or effectively total, we're not really talking about protection or association anymore. We're talking about colonization. But that grey scale is quite long. And right at the other end, you have entities like, states, like Cook Islands, which are, in my view, possessing statehood in the fullest possible sense, with a few delegated powers for logistical, political, and economic reasons. And then you have, sort of further up the scale, entities like Puerto Rico, which lacks statehood, in my view. I mean, the official status is a commonwealth under US constitutional law, but in international legal terms, it is an associated state, small s, as it were. Now, when you look at the substance of these instruments, it's important to keep a couple of other things in mind. Firstly, there is a distinction, I think, in principle between entities that lack statehood by virtue of this degree of dependence on foreign authority, and states that nonetheless exist in dependent relationships. So although I've just belabored the point that this is a grey and sliding scale, because this is law and we have to have categories of some sort, you have to make a point along that scale and draw a categorical boundary. And as with all categories along scales, this gets messy. There might be indeterminate cases on the boundary, and all you can do in those circumstances are reason by analogy, which is what we try to do in the paper. And thirdly, and this is, I think, particularly important when we're talking about this new treaty and the position of Tuvalu, there is a distinction, again in principle, between entities that are created within dependent arrangements and established states that enter into them. Right? So there is no point post its decolonization where Cook Islands has not been in free association with New Zealand. This makes it at least presumptively different in kind from Tuvalu, which has been an established and independent state for a while before entering into the treaty with Australia. Now, the reason this distinction matters in principle is fundamentally because of what's called the presumption of continuing statehood, or the presumption of state continuity. This is a much debated element of customary international law at the moment, but fundamentally what it means, put possibly slightly too strongly by the great Vaughan Lowe, but catchily nonetheless, is that the road to statehood is a one-way street. Getting the status is hard. For full details, see my first monograph. But once you've got it, it's harder to lose it. You have to go some. So when we're looking at, I think what is not, Douglas is quite correct, formally a treaty of association, and certainly not a treaty of union, as in this current case, it is at least functionally a treaty of association. You have to bear in mind that Tuvalu enters into it as a sovereign state with the force of the presumption of continuing statehood behind it, and then you've got Article 2.2, which is, in terms of its statehood and its sovereignty, a slam dunk. There is no way to read that text that doesn't torture it immensely, that results in, at least at the formal level of positive international legal rules, a clear commitment to the sovereignty and the statehood of Tuvalu. Now, and I think this goes with all treaties of association and protection. International law and the level of formal status is one thing. There are still fine questions we can ask about the political probity of any given arrangement. We don't really do that in great detail in the paper. It's not our role as lawyers to do so. Ultimately, that's a judgment call for the representatives of the people of Tuvalu. But as Douglas says, there's this explanatory memorandum, and this seems to be a deal that they are very happy with. So, from our point of view, at the formal level, everything is solid. We are closer to more modern treaties of association like that between New Zealand and Cook Islands. And everything else is another question, as I say. I hope that answers the question. I feel I've rambled a bit.
No, thank you so much. I just want to get back to some of the things we've talked about. We've talked about the legal side of it, we've talked about the statehood side, sovereignty, but there is this geopolitical side of it too that can't be ignored, the practical consequences of the treaty, how it's received. And Doug, you've been talking on the podcast a bit, and certainly in your work, a lot about legal statecraft of small states. So my question is, from the Australian point of view, this Falepili Union Treaty looks like a big win in terms of geopolitical influence in the area. Is it that one-sided from Tuvalu's point of view, or is there a win for them as well?
Yeah, so I think it's very easy to kind of look at the power disparity and the strength of the security guarantees and go, well, this looks like a terribly one-sided deal and potentially, in the language of Senator Shoebridge and others, a potential neo-colonial arrangement. It's not the view I take because, I start from a kind of presumption that small states have agency and the people in government and the elected representatives of small states are no more stupid or less virtuous than politicians anywhere, which may or may not be a particularly high bar, right? But, at the end of the day, these people are elected leaders who are trying to do the best for their country. And I prefer to think of the treaty as a potential example of something I've quoted her in the past on the podcast. Professor Beck Strating has said about the ability sometimes of small states to leverage the anxieties of their greater partners. So the clear context here is Australia didn't want to see another partnership between a state in our region, our neighborhood, and China. And what was Tuvalu able to extract for that? Well, actually, from its point of view, quite a lot. As Alex has said, existential continuity of the statehood of Tuvalu, a resettlement pathway for its people, and also in the short term, even having concluded the treaty, expressing anxiety about the treaty, got more than a quadrupling of direct financial aid to Tuvalu and got it, internet connectivity that it hadn't previously had. None of that small stuff. And it's not like this is a one-off for Tuvalu, right? It's very active in the climate space. It was one of the two founding states of the Commission of Small Island States on Climate Change and International Law, and brought the first climate change advisory opinion at the international level before the International Tribunal for the Law of the Sea, as we discussed, Imogen, in episode 4. So I think you can actually see that. So I've talked in previous episodes about the idea of a succession of cases on the same subject matter as being a kind of campaign of litigation where you try and move the lever of the law progressively in one direction. So Tuvalu's campaign isn't all litigation based, right? But it is addressing the same concern. So they are trying to both have to magnify their political influence on climate negotiations on the one hand, using ITLOS to try and put pressure on the COP process at the UN. But here also they're preparing for, worst case scenarios or even intermediate adaptation scenarios, which are obviously going to be very hard for states in its position. So I think, we can argue about whether it's ultimately a good deal or a bad deal for Tuvalu, but I think it shows very clear signs of canny negotiation, where having extracted quite a lot, Tuvalu is actually in a position to go back and extract more, and that this isn't a one-off kind of flash in the pan. It's part of an overall legal campaign by Tuvalu on a number of fronts to secure its secure its continued existence in the face of climate change.
Mm. And it is really incredibly patronising, isn't it, for the assumption to be that because there's a small state and a big state, that the big state has necessarily run roughshod over the small state.
Right. Well, but I mean, it's a very common view, and we'll throw to Alex on this in a moment. But one of the most frustrating things about one of my other kind of hobby horses, the South China Sea dispute, is the seeming insistence on the part of many Chinese officials that no one in the region has any agency, right? That everyone is either with them or is a cat's paw of the United States. So it's actually not only a sort of analytical failure by us as kind of commentators and scholars to sometimes go, oh, well, this is just being, the deal's being foisted on the weak by the strong, but actually, the literature written from the point of view of small states often notes that great powers will frequently overlook them and treat them as not even necessarily as sort of belonging to the same genus or order of being as the other big states. And sometimes they have to do things that are quite dramatic to get attention. And then sometimes you sort of see this scramble of improvisation from bigger states that have been caught quite flat-footed by the legal maneuvering of small states. Alex, I think there was something you wanted to come in on.
Yeah, thank you. I mean, I just, the geopolitics is definitely more your bag, Doug, than it is mine. And I'm not really qualified to comment on that. But one thing I would say from the sort of climate crisis perspective is just to amplify that point you make about the money, because it's as lawyers, we have this predisposition to think, or to hope, I suppose, that the answer to any given crisis must be a normative one. There must be some norm we can promulgate, or some position we can take, or some argument we can finesse that will solve it. But I mean, the stuff I work on state continuity and sea level rise, for example, is the absolute total last resort approach. Right. And far more important, I think, in practical terms, is the funding to offset loss and damage, funding to undertake prevention and mitigation. And, several small states won't even talk about this other thing, this supposed existential crisis. So Kiribati, for example, will not entertain discussion about it because they don't want to detract from what they see as the real challenge, which is building up logistical and economic resilience and going for the emissions targets. And so when we're looking at, as Doug says, whether or not this is a good deal, it may seem crass from the scholar's point of view, but the digits matter, because those are the things really that are going to help to protect and enhance real people's lives on the ground. And not to put too fine a point on it, keep the ground for as long as possible, which is really quite a serious matter.
And just coming back in on that, on the actual importance of money, a very significant part of the treaty is that, the human mobility pathway isn't a door that closes once you've used it, right? The treaty is designed for circular migration between Australia and Tuvalu, and that is how many people would anticipate using it. So remittances and the ability to build up capital and skills in Australia and go back to Tuvalu, either periodically or to kind of go out and return, is a significant component. And beyond the direct financial assistance provided by Australia, those remittances could be very significant for Tuvalu as well.
So I'm going to wrap up my questioning of you both substantively just by talking about process. Actually, because this is a co-authored article and it was written presumably with Douglas in Canberra and Alex in York. I should say I love co-authoring. Some of my favourite articles I've written have been co-authored and the ones I'm most proud of. But generally speaking, I think co-authoring is one of those things where when it is good, it is very, very good. But when it is bad, it can be horrid. Now, the fact you're both here and laughing seems to me to suggest that it was, in fact, very, very good. But I'd like to just see if you had any thoughts to share on the co-authoring process.
Yeah, Doug, do you want to go first? Or?
No, well, I'd sort of say start by picking a really terrific co-author who's terribly easy to work with. But I think that the sort of secret for a kind of good two-handed article is realizing there's an interesting question, but you can only answer half of it. And I think that was really how Alex and I came together on this. And we've been in sort of discussion through the pandemic and usually through Twitter DMs about a range of publication projects. But then we co-authored a short blog post about the Union Treaty for Eagle Talk. And I think doing a short piece first, kind of testing the waters and the bounds of an idea is often a good thing. We didn't do the blog post initially with a view to a longer article, but then just in the lead up to the Christmas break, I just sort of DM'd Alex basically out of nowhere. I went, I think there's a full article in this. Do you? And if so, should we try and get it as a current developments piece into a major journal? And good on him. Alex said, yeah. But yeah, so I mean, I think we sort of principally took responsibility for kind of our chunk each. And, you know, as Alex has just disclaimed knowledge of geopolitics, and I've been fairly quiet on questions of statehood, I think you can guess who was the lead author on each of those bits. But there was a lot of, you know, very friendly mutual overwriting. And I think sometimes it's actually a real advantage to have an author in a radically different time zone, because you can kind of get to the end of the day, clock off and know it's with someone else, but they might actually be something for you by the time you wake up the next day. So, you know, this, not that we were sort of that obsessively focused on it, but you know what I mean? There was a sort of natural cycle of productivity. I'll stop there before I start blathering.
Yes, we were sort of like the wholesome Dr. Jekyll and Mr. Hyde of academic writing, weren't we? Yes, you go to sleep, and
there's also that
Edith
line.
wakes up.
Yeah, there's also that line on the back of Good Omens that talked about, you know, Terry Pratchett wakes up early in the morning and Neil Gaiman wakes up early in the afternoon. This book was written in the few hours when they were both, you know, simultaneously awake. But actually, it was probably far more likely that, you know, Gaiman was up late and would send stuff off, and Pratchett would pick it up over breakfast. Anyway.
Yes, I mean, so I have to briefly contradict Douglas there, because I actually always wanted that blog post to be a longer paper, and and I jumped at it when he suggested it. So because I just, as I said before, I think this is such a significant development, and it needs to be both amplified and analyzed as much as possible. But look, I mean, I co-author quite a bit. Probably about as much as I write on my own. And I mean, my experience of co-authoring kind of differs depending on who I'm writing with. I mean, so I co-author with my wife actually quite a bit, and we write on legal pluralism together. New monograph by Routledge, available in all good bookstores. But
Link
sorry,
in
I
show
keep doing
notes.
that. It's become something of a tick. But look, I mean, that's a very different experience, because, of course, when I co-author with her, we discuss absolutely everything together, and of course, she's always right. But that, no, I mean, like, joking aside, it's far more of those are never publications of two halves, and so the experience is quite different. And I think when you try to co-author that way with somebody you're not absolutely on the same page as, that's probably when it can go very badly wrong. And I think Doug and I are very lucky in that we both do broadly agree about the law, and that we do have these kind of pretty siloed areas of expertise. So we are each other's kindest critics and most generous editors. And we're also, because of the time difference, ideally placed to as Doug says, sort of let each other get on with it. I just think, in general, when it comes to co-authoring productively, communication is the most important thing.
And
Just
trust,
sure that,
I think.
yes,
Which is
trust,
also,
absolutely.
yeah.
Trust,
and those are two sides of the same.
And I was going to say shared expectations as well, I think is very useful.
Well, we had, and we won't go into it now because we're probably already over time, but we had extensive suggestions from peer reviewers and editors at the American Journal. And I think I think we both reluctantly conceded that it was a better paper after we'd incorporated them in several rounds of correspondence with the editors. But I think one of the things that got us both through that was, I think, at least as regards this paper, we took quite a workmanlike approach. We thought this was an important development. We wanted to convey what was important about it. But the main thing was to not produce the best paper possible, but to produce a solid piece of work we could be proud of that we thought dealt with the legal issues. So it wasn't, like our baby was being called ugly when we got extensive feedback. We were more like, okay, well, we've got to get this through. Let's just sort of soldier on and we'll do what they've told us. And then at the end of it, we went, oh, look, I concede through gritted teeth, this is probably a better paper.
Our baby is in fact prettier.
Yes, exactly. The worst interventionist editor is the interventionist editor who is absolutely right. Nothing is as galling, but no, it definitely made the paper better. So ultimately, I'm grateful for it, even though there was gnashing of teeth at the time.
I can see some resultant trauma on both of your faces as you discuss it. So I'm going to start bringing things to a close, but we do have a segment that we sometimes have at the end of our podcasts, occasionally called Sidebar, in which one of us, now Douglas, who wrote the script, says usually Douglas, but I don't think that's true. I think there'll be time for all of us to have this segment. But we have Sidebar when we want to correct or clarify something that we said in a previous episode. And Doug, you wanted to clarify something that you said on episode 20 about the role of necessity in self-defense.
Right. Yes. Look, and we are well past time, so I'll try and keep this to no more than sort of 3 minutes. But so in episode 20, when we were discussing Israel's invasion of Lebanon in its conflict with Hezbollah, I noted that the case for the unable or unwilling doctrine is very weak, a position I wholeheartedly stand by. So I don't believe there's an established legal right to conduct extensive open-ended military operations in response to hostile non-state actors in another state's territory, even if there has been an armed attack and the territorial state is unable or unwilling to act against the non-state actor. Now, I noted at the time that could leave a situation where a state has been subject to an armed attack by a non-state actor, but cannot act in self-defense. However, I noted the obvious answer to that was either Security Council authorization to take relevant action or invitation from the territorial state. Those would be the answers the positive law allows. Now, absent such a resolution or invitation, can a victim state of an armed attack by a non-state actor really do nothing? So the kite I flew in that episode was that while such a use of force would normally be unlawful, perhaps it could be justified by the doctrine of necessity as a circumstance precluding wrongfulness. That is, a limited strike against the non-state actor might be justified by a necessity of self-defense, instant, overwhelming, leaving no choice of means and no moment for deliberation, to quote the Caroline incident formula, which after all involved rebels in US territory carrying out raids in British Canada. Craig Martin then very kindly called me out on Twitter as to whether I was really backing the doctrine of necessity as a third exception to Article 2.4 in the UN Charter, and noted that while there was some academic support for that proposition, Jure Vidmar in 2017 in Agel, for example, it's not a mainstream view. He also noted that my dear friend Frederica Perdue has argued that the general law of justifications and excuses doesn't apply to the Charter prohibition on the use of force. And I am happy to defer to Frederica as the expert on justifications and excuses in international law. Now, Craig's preferred way to square the circle is to focus on the Nicaragua case test as to when actions of a non-state actor might be attributed to the state, in particular the standard of being substantially involved in the attack. That is, he thinks in some cases being unwilling might cross the substantial involvement threshold. The argument I was probably trying to channel in my very mangled way was actually made by Kimberly Trapp in ICLQ in 2008. So her point was that one didn't necessarily need to prove or disprove a rule permitting action against non-state actors in a third state's territory, nor confine such action to cases where the non-state actor's attack was attributable in some way to the territorial state. For her, responses to such NSAs are permissible so long as they comply with the basic established rules of necessity and proportionality strictly construed. So one of her examples was thus the Israeli raid at the Entebbe airport in 1976. So she emphasized that such an action would not have been necessary had Uganda been acting effectively to resolve the situation, and it would not have been proportionate had any wider action beyond the airport or hijacked aircraft been taken. Now, I'm not sure if Kimberley still holds that view, and one might see it as a bit unable or unwilling light. But that would absolutely be the furthest I would go. That within the established requirements of necessity and proportionality, there might be a justification for taking very limited action against a non-state actor in a third state's territory, but it would need to be something analogous to the Caroline situation where you had like an incipient cross-border raid, you could see the attack coming and do something about it, which notably, those criteria weren't even satisfied in the Caroline incident itself. And I'll leave the rant there.
So 2 things can I say before I really wrap up? I feel like I'm almost doing a comeback tour. I'm going to wrap up and then I wrap up a bit more and I'm wrapping up one more time.
The audience is just clapping you back on for another encore.
Exactly. So first I want to say, I think, Doug, the idea of the sidebar and certainly what you did there is incredibly gracious in terms of, engaging with people who, as you say, very kindly call you out, but nonetheless challenge what we're saying. And I think it's really important that we do that as international law academics and have the grace and humility to accept challenges to our own views. Secondly, I think the Caroline incident is one of the most misconstrued things in international law. It's the case.
We could do a whole episode on our favorite completely misconstrued case. Like I can go off about Lotus forever, but anyway.
Did you have me back for that one?
Yeah, okay. Let's put it in the pipeline. Future episode ticked off. Okay, so I'm going to finally wrap up now, and we have 3 traditional questions. I'm going to direct the first 2 to Alex and the last one to Douglas. With the 2 to Alex, they are, what are you working on now? This article is obviously out. You said you have a book with your wife that's also out. What is the project you're working on now those ones are done? And what do you do to get away from international law? What do you read or watch or view or listen to take your mind off international law?
I'll take those in reverse order, if that's all right, because the answer to the second one makes the first one quite amusing, to me anyway. So I do lots of stuff. I paint and play Warhammer 40,000, which is a tabletop war game. I don't know whether any of your listeners are familiar. I know at least a couple on Twitter are.
Everyone who heard the episode with Alonso Gourmendi should at least be theoretically
yes,
exactly with the concept. Yeah.
Alonso is one of those people I had in mind, actually. Yes. So I do that. I run a game of Dungeons and Dragons, although we haven't played that in a while for various reasons, but that's a big hobby. I lift. I do sort of powerlifting type stuff, a bit of bodybuilding, but I haven't done that very recently either. When I really want to escape, though, I listen to opera or more specifically music drama. I listen to Wagner, my favorite composer. I find nobody takes me away from reality or perhaps bludgeons me around the head with reality as much as Wagner's music does. The reason that this ties into my work is one of the projects that I'm doing at the moment is actually a paper on legal philosophy and legal symbolism in Wagner's Ring Cycle. So trampling all over my work-life balance. That's one. I'm also co-authoring another article that's currently under R&R on sea level rise and state continuity. Again, I'm conscious that Doug is here, so yes, I am writing the manuscript for an OUP elements book on state creation, so hopefully that shall be done in the not too distant future. And I'm very, very lucky to be co-authoring an article with 2 absolutely outstanding ECRs from UCL and Surrey in the UK on quite a fine but I think rather important point of the philosophy of international law, which I'm enjoying immensely. But yeah, so that seems like enough to be getting on with for the time being.
Certainly quite a bit.
That seems like an awful lot indeed. Well, then I'll turn to Douglas for our final question and traditional question. Doug, can you describe for the listeners what you are wearing tonight?
Right. Well, during the day, I was wearing a light blue wool jacket of recycled Italian wool and a paisley bow tie. both of which I've shed for the comfort of the evening. But the thing I'm happiest to be wearing is a brand new waistcoat, which I recently had made by the local mum and dad tailors down the corner from me, which has been made out of a lovely Japanese print fabric, just sort of delicate white scallops on a navy background. And the fabric was brought for me by my parents-in-law on a recent trip to Japan.
Oh,
So
lovely.
it's going to be a traveling companion on my upcoming 10 days in the US. And at my suggestion, my tailor Loanne very kindly included a passport size interior pocket in the waistcoat. So I can be free of that fear I always have of where the hell's my passport? Like there is one place it's going to be meant to be for the whole trip.
That seems very, very sensible indeed. And I can verify for our listeners, the waistcoat does look very nice on Zoom. Well, we have come to a close. So thank you, Douglas and Alex. That was a fantastic look at your new article. And we'll bid you all good night, or in your case, Alex, good morning.
Thanks so much, everyone.
Good morning.
Yeah.
Nice.